turn the program over to Marta Vanegas, who is the section leader for the business law section, and she will introduce our panelists. Marta, you're muted.
Why? I'm going to share my screen and start with the PowerPoint and tell you the story from the beginning. That's a good place to start. So this is our last presentation, the end. We will have a refresher on a company's duties as an employer that interestingly, even though I practice mostly employment and small business law, did not get presented because I can't counsel myself. And whoever I try to nab for this presentation then got other commitments. So here we are. I'm going to go in character as Marta Stewardess, and we are going to refresh on the story. So here are the characters. This is me, Marta Stewardess. I am a graduate student at Polytechnical College of San Francisco, and I study chemistry. I expect a PhD next year. My favorite movie is Sideways. Here is my favorite wine, and my hobby is winemaking. Now, as a chemist, I'm really into the chemistry of winemaking. I have a friend. I met her at a Sideways screening at the dorm. She's Whitney Pearson, and she's also a graduate student studying computer science and business, expecting double degree in an MBA and a master's in computer science. Here is her favorite wine, and her hobby is cooking and pairing her recipes with wine. And we had another roommate or a dorm mate, Marta. She is also a graduate student studying electrical engineering, expecting an MA at the end of this year. And we also met, the three of us met at this Sideways screening. That's her favorite movie too. She likes South American wines and studies to be a sommelier in addition to being an electrical engineer. And we decided to start a small business by creating a device that will monitor the key chemicals during the process. So my idea was the chemistry. Whitney contributed some computer science, and Marta did the hardware design for this device, built a crude prototype in the school's engineering lab. We refined the algorithms, and we started to produce the wine. The results were surprisingly good. We dubbed this device the Sideways winemaker, and we had some dorm parties. It was a hit. Everybody was very curious how we can use a gadget to produce this excellent wine. Designed a cute wine label, designed a cute bottle. We had a little website, described how good this wine is. So all was going really well. And word soon got around. This is, after all, San Francisco. And other amateur winemakers began asking about the Sideways winemaker and if they could purchase one. So we got excited about maybe manufacturing this widget, the Sideways winemaker widget, and sell it. However, we had to say goodbye to our engineer who went to take a nice job in New York City. And it was just us two, Whitney Pearson and Marta Stewardess, starting a company. By now, we have formed two entities to run our affiliated businesses. We have a limited liability company for making the wine and selling the wine. It is very hot in Silicon Valley. Everybody wants to try the wine that was made by an electrical engineering device. And there is a corporation that is taking in venture capital for manufacturing this widget. We have raised funds. We have found the location and rented it. We secured the IP and started producing the winemaker and the wine. And then we ran into all sorts of problems. So these problems are really frustrating because we can't just throw money at them and make them kind of go away. Here's the thing. So we missed that consultation with the employment attorney, and as a consequence, when we terminated an employee, she sued us for misclassification as an exempt employee. We had hoped that we could have cash flow sufficient to settle this dispute, but we can't because our supply chain kind of froze and we cannot get either parts for our device or bottles for our wine. So both our companies, the LLC and the corporation, are unable to turn around and sell, or unable to actually put wine into bottles and sell. And we are just kind of stuck, and all sorts of bills are coming due. Employees are leaving us because we cannot afford the high wages that this current market demands. So we are just about broke. This is the sad truth. And we are going to talk to our business attorney. So here is how we are gonna meet the following lawyers. We're going to meet first with our business lawyer, David Pearson, who is the partner at Brothers Smith. He has spent decades representing closely held businesses and their owners. He works with his clients to resolve general business issues, whether it involves drafting and negotiating contracts, general business advice, or litigation. He handles general corporate matters, formation, dissolution, contract drafting, review, merger and acquisition transactions, represents clients in civil litigation matters, and serves on the board of the Contra Costa County Bar Association. David, are you secretary now? I believe he's going to be.
I am.
Yeah.
Hopefully president-elect next year.
President-elect next year, upward and onward. Okay, so then we will talk to the bankruptcy lawyer, Corrine Bielejeski. She is the owner of East Bay Bankruptcy Law and Financial Planning in Brentwood, California. She has practiced bankruptcy law for over 15 years and is still interested in learning more, primarily representing debtors and individual creditors. She's a CEB update author, regularly speaks on bankruptcy issues. Corrine is an active member of the CCCBA and her local PTA, and volunteers on the Delta PTA Association. And as I said, I really like her intellectual curiosity. There is her website, and we will see Matthew Olson. I called him the ABC lawyer. You will see why. He's of counsel at Dorsey and has broad experience representing debtors, creditors, fiduciaries in complex insolvency matters in cases involving both individuals and businesses. His practice focus is on helping companies navigate a bankruptcy reorganization from the first day of the case through confirmation of a plan of reorganization and resolving disputed claims, and all towards final resolution. When a bankruptcy case is not appropriate, Matt is able to help with other out-of-court options to resolve a troubled financial situation, such as ours. And he also helps creditors protect their rights in insolvency matters and helps professional fiduciaries discharge their duties and recover the maximum amount for the estates they represent. And we will talk to a creditor's lawyer, Cheryl Rouse, partner at Rouse and Bahlert, located in San Francisco. I'm probably butchering everybody's name, forgive me. She has represented secured and unsecured creditors in bankruptcy court for over 30 years. She has also represents parties in adversary proceedings as well as in state court litigation involving foreclosures and real property matters. And now, off to the meetings. So our first meeting was with David Pearson. And I'm gonna stop sharing. Hi, David.
Hi, Marta.
Hi.
What's going on today? How can I help you?
Well, first of all, Brittany is still out on maternity, so I'm dealing with all this headache pretty much on my own, although we talk on a daily basis, but she can just, hop in the car and come. And I find that there is about maybe 2 months more of liquidity in my company. I can't pay my employees. They are also leaving in droves. So eventually this problem is going to not exist anymore. I'm struggling with settling this lawsuit because I don't have the cash flow. I don't have the materials to produce the wine, to sell the wine. I don't have bottles. I can't get them. They ship them. So I already paid for them. They are just sitting in a shipping container, maybe in Hong Kong, maybe in the Pacific. I have no idea. My labels are not being printed because the paper is sitting on a container. So I had all these expenditures and I cannot get anything done. The semiconductor stuff is also, it's being shipped back and forth between 3 to 4 continents, and I don't even know where currently we are stuck, but somewhere we are stuck. So I just don't know how I'm going to deal with this problem when my cash runs out.
Well, unfortunately, we're hearing that a lot nowadays with businesses that have a lot of business but don't have the ability to fulfill it. And it sounds like that's one of your problems. And you and I have been involved in trying to work with the employee to resolve the employment dispute. But unless you can come up with some source of funds, either from you and your partner contributing money out of your own pockets or finding family or bank or someone, at the end of the day, we're going to have to discuss how to wind down this business while we protect what we can for you and your partner. And as you know, we discussed before with the employment lawsuit, those can potentially skip through the entity, and you and your partner were named individually as liable. So even if the entity can't pay, the two of you could end up personally liable to this employee because of the classification error.
See, that's why I'm drinking this wonderful Vinho Verde at noon, because I just don't see how I don't have any more personal funds. The last time I was putting up money was when we placed this order for the gosh darn bottles to China, and now I can't get my hand on bottles, and I have all this raw wine sitting in the warehouse and I can't sell it. And I have the orders and I can't, okay, I've said enough.
No, and that's a problem, that you can't fulfill orders and your cash flow is shot, because if you don't have it to sell, you can't bring in any cash and you've already spent the cash on the assets. So, I mean, while I can't necessarily help you, I do have 3 partners that I refer these types of cases over to that can walk through some of the options that you have both as a business and individually, because you're going to potentially have to look at bankruptcy or some other options for both the business and for you personally because of that employment suit. If we can settle the employment suit and cover it with whatever cash is necessary, then potentially you won't have to file a personal bankruptcy. But otherwise, I'm going to have to send you over to my partners to discuss that. And Cheryl, Corrine, and Matt can walk you through what your options are and what those options might cost to make sure that your cash flow can afford those things.
Well, thank you so much. So let's meet them. Corrine, Cheryl, and Matt, can you join us?
Hi, Marta. It's so nice to meet you. And thank you, David, for suggesting that she talk to us today.
Oh, not a problem. I'm going to step out since it's way over my head on the bankruptcy stuff, but I'll be available down the hall if you need me, if things don't work out in bankruptcy court.
Thank you. Hey, Marta, so I want to talk to you a little bit just at the beginning. How much have you talked to David or somebody else about bankruptcy law? Because I think sometimes it's good just to give you a little bit of background about what that is.
So all I know is probably what I could absorb from the New York Times. I don't have any specific knowledge. David just said that is an option that I need to explore. I'm a complete newborn to this.
All right, well, let me give you some background information. So bankruptcy is a federal law, and it is applicable in all of our states with a little bit of nuances and difference depending on which state you're located in. If you were to file because you're located in Alameda or Contra Costa counties, you would be filing in the Oakland division. And if you filed because most of your assets were someplace else, you'd be in that division of our court. Each of our divisions is staffed with a judge or judges who are here to hear your case. And again, like I said, it is federal law, so it would be different than the state court litigation that you might be used to already. When you file, an automatic stay goes into effect that pauses most of the litigation that's pending against you. It doesn't pause some things, like if there's a criminal action and some family law actions aren't paused, but we'll talk about that a little bit more later. And then of course, our goal with the bankruptcy is to either get your debt forgiven or to get you into a good payment plan. And so David gave me a bit of information before, and it sounds like right now you're having some cash flow problems, right?
Correct. I see that I have liquidity for about 2 more months. But that's it. Unless some miracle happens, I'm not fulfilling orders at this time because I don't have bottles and labels, and it appears that I'm just stuck.
Okay.
So my supply chain is stuck somewhere on the Pacific, and I can't get whatever I paid for to be shipped us.
Okay, well, there's a couple of different options. So bankruptcy isn't just a one-stop shop. We have different chapters of bankruptcy. So what most people think about when they think about a bankruptcy is something called Chapter 7. That's a liquidation bankruptcy, and businesses often file that when they're going to close their business down. And so what happens in that, it's really a quick filing. You file the case and you'll meet with your trustee about a month to 2 months after the filing. Your Chapter 7 trustee is going to take over the business. So the day you file, you're going to stop business if you haven't already, and they're either going to sell the business in whole or they're going to sell it in parts. Now, it's important to know that in a Chapter 7, if an individual files a Chapter 7, they'd be able to get a discharge, but when a business files a Chapter 7, they don't. But the good news and bad news of it is typically if a creditor is coming after you, you file the Chapter 7, all of your assets are going to go through the Chapter 7 process, so there's not really stuff there at the end of the case. What can also be a good idea with Chapter 7 is that you're putting somebody else in charge. So if you and your partner are disagreeing about matters, this can be beneficial because you've got somebody else other than you who's making those decisions. I do want to let you know that the trustee is charged with investigating preferences, insider payments, all sorts of things that we do out in the real world that just don't make sense in the bankruptcy world. So I believe David said that your lawsuits are against you personally as well as the business. Is that right?
Yes, it is a wage and hour lawsuit. And the statute says that any person who violates this statute and any agent of a company who violates this statute is liable. So
Okay.
It's not just the company, but apparently I'm on the hook, which is not great because I thought when we established the company, we would not be on the hook.
And you know what, that happens to a lot of people. So that's why I gave you the conflict of interest waiver before you came in earlier today, because we are going to talk about both the business and your personal liabilities as far as that's concerned. So if the business files, like I said, if they file a 7, the business isn't going to get a discharge. So if that employee isn't paid in full, they might still continue to go after you. So there is a chapter of bankruptcy called Chapter 13, and that is an individual bankruptcy. So oftentimes I'll see this for people who they're closing a business, or maybe they're not a business owner, but they have other debts that they want to include. So with a Chapter 13, thanks to some recent law changes, you can file that if you owe up to $2.75 million. So hopefully, I'm hoping that your lawsuit is still underneath that, and the rest of the debt for, your name being on a lease and that sort of thing. And that'll be good for about another 18 months. So you don't have to make a decision today about filing, and you'll still get that higher cap. We often use 13s to get you into a good payment plan. So just personally, do you have some other debts right now that you're dealing with, like credit cards and other debts?
Well, as a business owner, of course, there were some things that I put on my personal business card, and the business has also a business card that is kind of mixed out now.
Yeah, I mean, and that's really happening a lot these days. The amount that people are owing in credit is getting really high. So what you would do is we'd propose a plan, and in a chapter 13, you'd pay that for 3 to 5 years. And at the end of that payment plan, whatever you haven't paid for is generally discharged. Now, of course, there's always exceptions, right? So I can't get rid of those student loans in most cases. And then if you want to keep a car or a mortgage, you're going to have to keep paying that car loan or that, that house. That's just the way that the bankruptcy world works. And like I said, 13 is just for an individual, but we do have a reorganization plan available for you as a business. Do you want to hear more about that one?
Yeah, sure. As
Okay.
I said, the business is also in trouble, not just because of the lawsuit, but because, I mean, we could probably settle the lawsuit with some installment payments if we had cash flow, but we don't.
So the other option that a business has is something called a Chapter 11. And those ones are typically a reorganization plan. And often people are doing that to either sell a business as a whole entity to somebody else or sell off different parts of it. So I understand that you've got both the manufacturing side of it and more the tech side, as well as the wine itself. And so with a Chapter 11, you can either continue to operate the business or you can just do an orderly shutdown. And what you're going to do is propose a plan just like an individual would in a 13, but the difference is your creditors get a chance to vote on it. And so you have to really work with them. And Congress recently added an additional type of Chapter 11 called a Subchapter 5. And in that chapter, what's great is that the Chapter 11 trustee gets together with you and with the creditors, and they're really trying to create what they call a consensual plan where everybody can get paid. Of course, that can't always happen. If you don't get that cash flow, then there's no money to pay them, obviously. But that's always the goal. Subchapter 5 can also be a little less costly. So we can talk about that a little later in terms of how much debt you have and if you qualify to do the Subchapter 5. With all these business ones, though, it is important that your board be able to get together and vote on these. So your board is going to have a vote, and they're going to vote to file the bankruptcy or not to file if they want to go with another option. And you'll record that in your meeting notes just like you normally do. The other thing that I do have to let people know is that with the Chapter 11, you can't do all the same business things that you love to do now. So I know typically right now you're paying your payroll and you're paying your leases as those payments come due. Unfortunately, with 11, you're going to have to do monthly operating reports to kind of disclose everything to the court. And then you're also going to have to do to get permission for all of your cash collateral and payments. So they just want to make sure that, you're not off paying yourself $5 million and not paying your employees or paying the rent and those sorts of things. So,
Right.
and you don't have to worry. Those ones are pretty typical. We even call some of these first day motions because they happen so much at the beginning of the case. So those are kind of the things that we'd be looking at in a bankruptcy. Did you have other questions I can help you with right now?
So I just don't know how to put this to my board. What are the risks that the creditor will not like this and will attack us in litigation?
That is a great question. Let's bring in Cheryl. So Cheryl actually is the one who will represent creditors. So if you were a creditor in a case, she'd be the one who'd be talking about that. Cheryl, can you talk to Marta a little bit about what the risks are and what you as a creditor in this case might want to do if you were representing them?
Well, it depends. Marta, do you have a lease?
Yes.
Facility? Okay. And are you current on the lease?
No, we are about 30 days late.
Okay. So, if you file a Chapter 7, it's going to be, you have to shut down. But if you file a Chapter 11, then you've got a little bit of breathing room to decide what you want to do with the lease. And you have to either assume or reject the lease. And if I was representing the landlord in this action, you would have to, if you decided to stay and work through the Chapter 11 and stay in the facility, then you would have to bring all the arrears current on the lease at the time that you accept the lease. And there's a deadline of accepting the lease. I think 11, isn't it? Isn't the date of confirmation? I believe.
I was
think
gonna
it's a
say,
data
I
fund.
defer to Nat for that one because all my clients are either current or giving it back immediately.
I thought it was confirmation or 270 days.
Yeah, I
but
think
it's
it
been
is.
a while
Yeah.
since I
So you
looked
have to decide whether you want to keep the lease or not. You might want to get rid of the lease. And if you get rid of the lease, then it becomes, then the liability is you've got pre-petition liability for rent that you didn't pay before you filed the bankruptcy case. And then you've got post-petition liability for rent. And that becomes, in a Chapter 11 case, becomes an administrative claim, which means you're going to have to pay it if you want to go forward with your Chapter 11 case. The other thing is, do you have, I know you've got an LLC as well as a corporation. So are you contemplating filing, possibly filing for both?
So the
What the
LLC
structure is.
is broke because we have all this wine, they are in plastic vats. And we are supposed to put it through the bottling machine and there are no bottles. And if we leave it in the plastic vat, it's going to spoil. So if I don't get the bottles in the next 5 days, I might as well just drink all the wine in one sitting and call it a day. Because it's not going to, it's a 50-gallon vat, so it's going to get me plenty drunk, probably poisoned, but it's not going to go into bottles and it's no longer sellable. The quality is deteriorating as we speak.
Well, do you have any loans? Does the business have any loans where there's security, UCC1 security interest that's been filed on any of the equipment or the wine or any of that, any of those things?
So the corporation has some secured notes. The one that is manufacturing the winemaking widget, where we cannot fulfill orders because we have semiconductor parts en route somewhere on a container, also stock. And so I cannot make money in that company either. Other than the note, the convertible notes, we don't have secured. I mean, we do have a vehicle. So that's secured by the vehicle. But I also, we have credit cards, and I put in a lot of money into the company as a loan to the company, the corporation, before venture capital was funding, and I never really paid that back. So I'm also a creditor to the corporation in that sense.
Okay, so just one point though, if there's a security interest, if you've gotten a loan that has taken a security interest in any of the equipment or maybe the wine, then maybe sitting and drinking the whole vat of wine might not be a really good thing because you've just gotten rid of some of the security.
That
for
was
the note. So you just-
hyperbole, but it's at
Yeah, I
that
know.
point the wine is going to become vinegar and
Right.
no longer.
Right. Anyway, you need to be careful how you dispose of assets where there might be a UCC1 security interest against those assets. The other thing you should be careful of, if you if the corporation files a Chapter 7 or the LLC files a Chapter 7, you need to make sure that, for example, do you have a car that's titled in your name, but the corporation's maybe been making payments on it?
No.
Those things could be brought back in. Okay, what about the credit cards? Has the corporation been making payments on your personal credit cards?
Well, no, the corporation
Okay.
hasn't been making payments.
Okay.
I have been making minimum payments on my cards. The corporation, though, owes me that money
Okay, okay,
in a technical sense.
okay.
I understand that it's not secured, so probably the secured creditors are first in line, right? That's why they secure.
Well, to the extent they have a security interest in something.
Yeah.
I mean, it's not just a general sort of security thing.
To
It
the
has to be a
extent of theirs.
yeah,
Yeah.
it has to be
Okay, I got it.
security interest in thing. And then as Corrine says, filing Chapter 7 is not going to help you as far as the lawsuit goes.
Mhm.
So, I mean, it's there's the corporation doesn't get discharged. And so you're going to have to deal with it, deal with it on your own since it passes through. So anyway, those are some thoughts that I had.
Cheryl, can you talk a little bit more about which cases they might have to deal with an adversary proceeding and what an adversary proceeding might look like for her?
Well, I mean, an adversary proceeding is generally when someone's trying to determine a debt is non-dischargeable. And so if it's a Chapter 7 in this case for the corporation, I don't see that. I don't see that happening. Now, if you file an individual Chapter 13 for some of the debt, if for some reason that lawsuit out there fits into a category of fraud, you made misrepresentations to your employee, or you maybe had a fiduciary duty in terms of actions toward the employee, then she could file a non-dischargeability action in the Chapter 13 and try to have that declared non-dischargeable as to you. The good news in Chapter 13 is that there's one of the sections is Section 523A6, which is for willful and intentional injury to the person or property of another. And a lot of times employment debt, wage and hour claims can fit under that A6, but in a Chapter 13, the Chapter 13 is, A6 is not available in the Chapter 13. So if you did file a Chapter 13, you wouldn't have that kind of liability exposure.
I'm good and confused now. So what else do I need to know? Is there a light at the end of this tunnel?
So, I mean, here's what I can tell you. The benefit about filing a bankruptcy is that, like we said, most of the lawsuits against you might be paused during the case. That can give you a little bit of breathing room. But, unfortunately, you are going to have to notify all of your creditors. You're going to have to list all of your assets and all of your debts. So everything is going to be on the docket there. And when we say everything, we mean everything, right? So we're going to be going back through transactions between you and the business. And that's what Cheryl was talking about a little bit ago. And we're going to be talking and checking to make sure that there were no fraudulent transfers or what we call avoidable transfers. Again, anything that you've done in the real world where the business has been paying you and you've been paying the business for certain things, or if that happened not with you, but with your business partner, those could cause issues in the bankruptcy world. And we always joke, the best way not to have a bankruptcy crime is not to file bankruptcy. So the benefit that we have in our bankruptcy system is that it's, all of us are very experienced, so we can make sure that you are adequately listing everything and everyone. But you know what, I do have to tell you, you're not going to be able to make as many decisions as you normally would make if you file the bankruptcy. I really love it as a great way of saving a business if you can't get your creditors to agree. But, my colleague Matt has some information about different options that don't involve bankruptcy, if you'd like to talk to him about those.
Well, hello, Marta, and this is a very interesting conversation. Lots of things going on for you, but let me talk about one of the sort of not out of court necessarily, but an alternative to bankruptcy. It's called an assignment for benefit of creditors. And it's a good solution for companies that are either trying to wind up their affairs or companies that are trying to sell their assets. An ABC, as we like to refer to it, is an out-of-court process in California. There's no court filings, there's no docket, there's no judge, and it's pretty expeditious and private, obviously. So it's a good solution when you have perhaps a very public situation that you want to make less public, or a situation where you need to resolve it quickly and at lower expense than sometimes what a Chapter 11 bankruptcy would cost you. The real touchstone of an ABC process is consent. You need consent from the company's management and its owners, which is something that's you don't see in a bankruptcy case. The management can make the decision on its own. In an ABC, we need the company's owners to consent. The other big component is we need secured creditors to consent. So I heard you say earlier that you had secured debt for the company that was operating the widgets, the product,
Yeah, we are manufacturing the sideways winemaker widget, the SideYY. And we have some convertible note holders. And we have a car loan. So the company owns a car. It's kind of like one of those car, but van, but car, hybrid thing. With a logo on it, and of course, whatever payments we made is barely made a dent, but now the car is worth half of its original value. So,
right. Now, the convertible note holders, they have a security interest in the company's assets.
correct.
Okay, so how friendly are they? Are they very hostile to you right now? Are they pretty friendly? Or...
They are friendly. They understand that it's not because of any bad planning or bad business decisions that were made. They are on the board, so they are participating in decision making, but they understand that this is a 2022 problem that we have, is that we have stuff we paid for, it is being shipped, it's just somewhere. We don't even know where it is at the moment. We just know that it's not coming soon enough for the production. It's more urgent for the LLC that we have, because as I said, the wine does not get better with age in the vats that they are in now. So we looked at alternatives such as barrels to store the wine, but they are very, very expensive and we don't have sufficient money to purchase them. And this decision needs to be made in the next 5 days on what to do. So we have people who would probably agree to a solution to tide us over this hard time.
Okay. Have you been working with investment bankers or anyone else about a sale of the business? Have you had any conversations about that?
No, I just went to David Pearson today because I looked at the books and I saw what was ahead.
And the goal here is it to preserve the company, or is it to do a soft landing?
At this point, I'm trying to figure out what the options are to bring back to the board on the corporation side and to my partner on the LLC side with the wine. As I said, we can probably let our purchasers of the widget know that it's coming, it's just going to be delayed. My problem is I can't keep employees, so I have to let them go, hire them back. So then it's going to be even more delay without any cash flow. But the wine is really,
It's
really a pressing issue, yes.
Right. So let's
That's
talk
the
a little bit more.
curveball.
Assuming that you have consent, so the ABC process can take kind of two forms. One is you would bring in a proposed assignee. So this person serves much the same role as like a receiver or a bankruptcy trustee. The difference is that you get to hire them. So you get to interview and choose the person who has sort of the best qualifications. And then they will run the two options is they either run a sales process in advance of the assignment, or they run the sales process after the assignment. Running it before we call a pre-pack frequently, and that's best when you're trying to do either there's some urgent issue that needs to be solved, or you're trying to sell the business as a going concern. Because that way, once the assignment happens, they can close the sale at the same time. The employees walk across the street and everyone keeps marching forward. The sale after an assignment, frequently you're dealing with residual assets, sort of a liquidation value sale, not a going concern value. So
if we could save the wine somehow,
right,
and then I'm pretty sure that even that business is worth much more as a whole than it's in its components. Just it's not worth much.
Right.
It holds a bunch of the sideways winemaking widgets, because that's the way we make the wine, holds a bunch of these plastic vats and a bunch of sugar and grape.
Right. So the process would work is you would interview and hire an assignee. There's professionals who do this every day, many based here in the Bay Area. They would run a process to the people that they know. They'd also work with you on people you know who might be interested in, people they could garner interest from in your particular market, and then put together a teaser sort of document, get information out into the marketplace, work with you on building a data room, and then have people sort of get information and try and put together offers pretty quickly. Again, 5 days is probably a little fast. They might be able just to deal with the wine to preserve the value of that particular asset and then do a larger process on the rest of it. I'll confess to you that there have been several wineries that have gone through sale processes, either bankruptcies or ABCs in the past year. So there's definitely a market out there for this to work on quickly.
Right.
The other big benefit of an ABC is, again, you get an independent fiduciary to come in, and they're the ones who then manage the claims process with your creditors. So they'll send out a notice. By law in California, there's a bar date set about 6 months after the assignment happens, and if people don't present their claims, then the claim is disallowed under relevant law. The process is, while it's not on a public docket, it is kind of regimented, and there is a familiar sort of approach to it. People are kind of familiar with how that claims process works. It's followed by a formal windup of the company, so there's not going to be some sort of residual entity hanging out there. The assignee will help you wind up the company formally under state law. Now, the big disadvantage is there's no automatic stay. You heard Corrine and Cheryl talk about the automatic stay. That's that statutory injunction that stops collection actions. There's no such thing in the bankruptcy, I'm sorry, in an ABC. So that's not going to solve your litigation issue, although it would sort of force the claimant there to present their claim to the ABC estate. It's also not going to solve your personal liability problems, unfortunately, on that front. ABCs are less expensive, as I referred to, than Chapter 11 bankruptcies. Typically, an assignee's fee for a case your size is probably somewhere in the $75,000 range, and then they'll need a budget to run the actual process. Good thumbnail is probably about 100 to 150,000. This is a good time typically to talk about it. You said you had about 2 months of cash left. I normally recommend to my clients that they start having these conversations when at the latest, the 2 months, 3 months is better, 6 months is even better if you've got that much cash left, just to make sure you have the runway to pay for the final sort of burial costs of the company. Other questions about ABCs or?
Well, this is a lot to think about. Of course, I will probably have questions later once I have digested this information, and I understand you have something in writing for us.
Right, I have distributed, I did provide you with sort of a one-sheet document that kind of talked about the strategic alternatives that you can look at, and then also there's a 2-page document that talks about things the board and the company should keep in mind when they're in a difficult spot.
And Matt, just real quickly, can you tell Marta what your role as attorney on this one would be? Would you be assisting the business owners when they're closing it up? Would you be helping out with the professional fiduciary, the assignee? What would your goal be to help in helping her out with the situation?
In this case, we would help Marta and the company. we'd help you navigate that process, hire the assignee, review and execute the assignment documents, and then kind of transition things over to the assignee. In the interest of disclosure, you should know that we do represent the professional assignees, many of which operate in this area. So it's very likely that whoever you end up selecting, we will have worked with in the past, although in other unrelated matters.
Thank you, Matt. Hey, Marta, I know we've given you a ton of information about the different chapters of bankruptcy law and workouts, and Cheryl mentioned that some creditors, unfortunately, the litigation, might be paused during the bankruptcy, but may not stop, especially if you've got a personal one. So I always like to say, we want to keep talking about your personal options on one side and your business options on the other side. But is there anything else that we can talk to you about for the business at this time, or do you want to just go back and think about it some more?
I'm going to take this back to my business partner and to the board, and we will probably have another meeting where we can make the decision. It's good to know that there are so many options. It really helped this conversation. So now I'm going to go back and discuss what I learned with David Pearson, my business lawyer, and I'll be in touch.
All right. Thank you, Marta. Bye.
Thank you. Hi, David.
Hi, Marta. So how did the meeting go with all of my bankruptcy partners?
It went fantastic. It went fantastic. They advised me so much. And, in the intervening week or two since that meeting with your partners, some miracles have happened and my prayers were answered. So I find that it's good that I learned these options because we still have very little cash on hand. As Matt said, that I should consider these options at 6 months. I'm still only ahead a little, but guess what happened? The wine bottles came in just the last morning when we were thinking of shipping the wine to a different facility for making vinegar out of it. The wine, which would not be a great idea financially, but it's still better than nothing. The wine bottles were delivered in 2 huge containers, and we popped the containers onto the bottling facility, and they are now being rolled out and sold. So cash is coming in. These were all pre-orders. So that business is saved. And then we got news that the semiconductor is in about 7 days out at the Oakland port. So in about 7 days, they will process the customs inspection of that container, and I will be able to put together. This was like the final step before the widget can be packaged together and shipped. So in about 10 days, those shipments are going to start to go out. So it looks like we averted this crisis, David. And thank you for introducing me to these folks, because I'm still on the verge of bankruptcy. I don't think that this is just the immediate pressure is off, but I don't think that this is going to be sustainable if our supply chain is entirely uncontrollable. So what options do I have?
Well, I mean, you heard from my bankruptcy partners about the options with the ABC and bankruptcy and kind of the lead times, especially if you're looking at an ABC. But if you have cash flow and product is coming in, even if it's intermittent, to be able to ship and keep your doors open, we have enough cash to settle the employment claim, which will take care of that liability. Unless you have personal guarantees on any of the other debt, you and your partners don't have to worry if we decide to close down the business. Now that you have the operating capacity to keep the doors open, at least in the short term, the options are to just run the business out, pay off everybody that we can, and then close it. Start the dissolution process, and the creditors can do what they want, but at the end of the day, since you don't have a personal guarantee and you've run your business appropriately without taking money to pay yourself, pay your personal debts and running personal expenses through the business, they can rattle their sabers, but they're not likely to get anything from you. So we can negotiate with them on a wind down, or we can retain a business broker, an intermediary, to go see if we can find a buyer. It's a going concern. Because while you may be having trouble getting supplies, you have a good business, you were able to make good money for it. And if you could get a steady supply of bottles and labels, you'd be able to continue operating. So maybe if we find a larger buyer who has a steady supply, they can continue the business and actually pay you. So
Right. So I think what I'm seeing is happening is that I was aiming to be a chemist, and this is just, it's not something that I foresaw as activities that I have to be doing to monitor shipments and deal with employees walking off. And it just feels like we have a great product, but maybe somebody can do what I do and what Brittany has been doing much better than us. So either we would wind down the business as you suggested, or we would sell it. Now, if we don't sell it, because that's probably a separate discussion, but if we want to wind it down, can we, in the process of that though, sell some assets? For example, we have or sell or license, or we can do something with the patent for the widget that we have secured at great cost.
So unless you have a secured creditor, and obviously with their assets, you would have to deal with them if you want to sell the asset. So if you could find a buyer who will pay you more for the asset than the security, you're free to go do so. Through the escrow, whichever process you choose to sell the asset, you'll clear the secured creditor.
So these are the secured, the convertible note holders. They have an interest in this asset, right?
Yes and no. It depends on what their secured notes say and what assets they're secured against. So we may have to negotiate with them to be able to sell. And we'd obviously, since they're currently shareholders, we'd have to let them know what is happening if you decided to shut down and liquidate everything out of the company.
I see.
Because of that conversion. But at the end of the day, that's one of the things you'd have to look at is if you go out to sell this, how much are you going to get for the assets? And are you going to be able to pay all your creditors or not?
Mm-hmm. Well, it's quite a valuable asset. The question is, are they interested in running it themselves? Is any one of them interested in buying the asset? Do you think that could be negotiated? These are venture capital firms and individuals who have lots of capital to invest in up and coming companies.
Well, everything's negotiable always.
All right.
Depends on the individuals and the companies you're dealing with. And again, the ultimate value of the assets, because the assets may have more value as a going concern than trying to sell them off separately. I mean, the individual components of your products, the bottles themselves, the wine, are unlikely to generate much value on their own, whereas a bottle full of alcohol that is ready to sell is worth more than the individual components. So you have to look at what you're selling and what values you can get out of it, and what creditors, if you have a secure creditor, we can negotiate with them to just assign to them the asset that they have security in.
I see. So on the wine, so on the LLC side, we not only have what we have currently, but we have some contracts about the grapes that we purchased on the vine.
And you may be able to resell those contracts, but again, we'd have to review the contracts to see if they are assignable. And nowadays, a lot of companies put into their contracts that you can't assign it without their permission.
Mhm.
So we'd have to take a look at that, or whether or not we're going to have to fight with the grape sellers over those grapes.
All right. Well, this is a lot of things to do on my to-do list to figure this out. So maybe we can schedule another meeting to review these to-dos and what we have decided. Would that be okay?
Sure. Welcome
Okay.
to not being a chemist and being a business owner where you get to do everything soup to nuts.
Yes, well, it was a fun adventure, but maybe it is time to pass it on to somebody else. I'm glad that I can, oh, I see that we have actually more time currently. My assistant just advised me that I can actually ask you pressing questions about selling the company as a going concern. So that is actually a very attractive opportunity in the winemaking widgets sphere. But also the winery. I mean, because we have these contracts to get the wine in, and we have the method of making the wine, and we already have pre-orders for, no kidding, for next year's wine, because this is Silicon Valley and everybody wants to get more of this wine that was made with a widget. So everybody is like, they want to get the techie wine. That's a nickname in TikTok, the TikTok tech. So, so how do you suggest I should approach this if I want to get the value for the winemaking business and get the value for the corporation? Let's start with the winemaking business.
Well, what we would do on both sides is retain a business broker or intermediary to sit down with us and walk through the process of bringing a company to market. And that person is going to sit down with you to see what you have, come up with what they think is a value, and they will tell you what things that you need to fix to get the most value out of the business. That may be cleaning up your bookkeeping methods. It may be bringing in some additional employee help so that you have what's called a transferable administrative core. Because if you are the entire business, that makes it a little bit harder to sell if it's just you and your partner and there are no other people, because everything is up inside of your head. So the business broker intermediary can walk you through the process of how to make sure you can maximize the value when you go to sale. And most of those people will tell you that it takes at least 6 months to a year to find a buyer. Given the size of your business, it's likely that you could find an individual buyer, somebody who is in middle management, they can't get they're unlikely to be promoted, and they're looking to buy a job. And your company is perfect for somebody who might want to buy a job and cash out their stock in retirement in their current business and take over running yours as their own boss. So
I see.
there are those people, and then there are other, obviously, large wineries that are always looking to acquire competitors and to buy market share and additional labels for their company. So there's lots of different options that a broker could bring. And you also have the tech, which is different from the traditional winemaking industry. So that may be attractive to a larger winemaker to have that technology to add in to the traditional winemaking.
Yeah. How about how much cash on hand do you suggest I have to be sure that I can manage this?
Well, it's not cash on hand, it's can you continue as an operating business? And that was the discussion we had, why I sent you to bankruptcy, because you didn't have enough cash to keep operating. If you want to sell as a going concern, you have to have the doors open. You have to be producing product and generating revenue and generating sales and paying your bills. If you can't do that, then you may end up either with bankruptcy or the ABC, or negotiating directly with secured creditors just to hand them the assets and walk away.
Mhm.
But if you have enough revenue to continue, enough cash flow to keep the doors open, then you have the time to take this to market and get the business to the point where you can find a buyer. But
All
it's
right.
take a lot of your time and effort to keep that going, and some luck to get the bottles and everything else that you need from overseas.
Okay. Okay. So I have my marching orders. I have to either keep running or have about 6 months ahead to do an ABC or to do a bankruptcy.
Correct.
Okay.
And, the sale process, as far as retaining the broker, is probably going to be less expensive, much less expensive than the bankruptcy or the ABC, because they will charge a small fee up front, and they generally work on a contingent where if they are successful, they get paid at close of the sale.
Like a broker would.
It's less of an impact on your cash flow to bring them in and start working with them up front than going straight to bankruptcy. But if you don't think that your business plan will let you keep the doors open, it's not necessarily a viable option.
Mhm. Mhm. Okay. Well, I think the business plan is solid, except we need to find probably resources on this hemisphere before before we can continue. So we are going to look into that. Maybe we can get all of my counsel into the same room for Q&A and see. I was looking for questions from the audience. I am seeing something about the lease confirmation point from David Arietta.
So Matt, that's you and David's point.
That was just going
Right.
back and forth. Yeah.
Yeah, section 365 was amended to extend the lease assumption to 210 days with an option to seek a further 60-day extension for showing a good cause. And then further extensions after that, you have to show the bankruptcy court good cause, but you also have to have the landlord's consent. But the 200, basically the debtor can count on 210 days, can likely get out to 270, and then after that, you kind of have to put up or shut up.
And those are circumstances where the debtor wants to keep the lease going. If you're filing a Chapter 7, remember at this point, you don't get to make those decisions. And that can be a really good thing if the business partners can't agree. They can agree to file the bankruptcy, but not the other ones. So with the filing of the Chapter 7, the trustee can actually come in on really shortened time in order to get rid of that lease so that they stop spending estate money. And so if you are a landlord and you're listening, that's something to keep in mind, that they can come in very quickly and try and stop that lease. All right, it looks like there's a question from Dan about the benefits of subchapter 5, chapter 11, and has it been effective for the cases filed? We've got a really good rate of acceptance in our Northern District of California. They are not always assigning local chapter 11 trustees anymore. So your subchapter 5 trustee could be somebody from LA, could be somebody, local and around here. But they're really trying to kind of treat these as regional. They can be less costly. And last year at the judges panel, they gave us a cost range from the low end to the high end. And I believe the judges panel is tonight from 4 to 6 p.m. And I think they're giving an update. I haven't reviewed the materials for that. Did any of my bankruptcy colleagues review the materials for tonight's program yet? No. No. So they gave numbers, and I want to say, back in the day, Judge Newsom said no chapter 11 can be completed without at least $50K in attorney's fees and $25K up front, at least $25K through the case. And the goal is for a subchapter 5 to be able to at least start it under that number. And of course, Judge Newsom hasn't been on the bench for a while now, but that was his comment to the bar was, don't walk into a case without a substantial check, just because of all the first day motions. The one thing to note about subchapter 5 is it's got a very short timeline for getting that plan filed. So you and the debtor has to file it. So it, unlike other cases where, you know, after that time limit runs, the creditors can come in and file. Debtors got to be prepared to do it. And you've got to look at your means test, because if it's an individual, you're going to have to pay at least that minimum, just like you would have in a 13. So keep that in mind in terms of numbers.
I
Yeah,
also,
on this,
okay, go ahead.
go ahead, Cheryl. Go ahead, Cheryl.
I've been involved with subchapter 5 as a creditors counsel in probably, I don't know, 6, 8 cases. And actually it's been a pretty smooth experience in most of the cases except one. The thing is, though, for creditors, in a subchapter 5 case, the case can get confirmed over your objection. So creditors in a subchapter 5 case have less, less tools and sway in terms of what's actually happening in the chapter, subchapter 13 plan. But because the goal is to be consensual, the hammer is that if it's a consensual plan, the subchapter 11 trustee is done. And if it's a non-consensual plan, then the debtor is going to have to pay the freight of the trustees through the end of the case. So that seems to be, in a couple of cases at least, it seemed to be what made the difference in terms of getting a consensual plan in the subchapter 5 case.
Yeah, I agree with Cheryl on that point. I think it's also important to note that there's no voting in a subchapter 5 case. There's just an acceptance or a rejection of the plan, but there's no requirement that you get a particular proportion of creditors to vote for it. It's also important to remember that the debtor is the only one who can propose a plan in subchapter 5. So if you don't propose it timely, you might be looking at a pretty difficult road on a motion to dismiss or a motion to convert.
And for those of you who don't know, what the motion to convert is it's basically forcing your reorganization plan case where there might be assets there into that chapter 7. And so that's kind of the stick behind bankruptcy laws, that if you don't do things timely and you're trying to keep the business going, they can force you into that 7 and, you know, everything's going to stop. And so clearly, you know, the court is looking at, one of its tests is what's in the best interest of creditors, right? So, you know, Your Honor, I need some more time. They're going to ask why you need more time and what's it for.
But the creditors have a conflict among each other, right? Because one creditor is like, I want the money now. And the other one is like, hey, but if we let them operate a little longer, we could get more money. All of us could get paid.
Right. There's that inherent sort of conflict between there, and that's part of the whole, you know, sort of consensual negotiation process, is trying to get everyone to the same page. The subchapter 5 is also helpful because it's the debt ceiling on that is 7.5 million for the next roughly 18 months, and hopefully that gets extended out. I haven't looked at the statistics lately, but the general wisdom is that that debt ceiling is high enough to cover something like 85 or 90% of the business bankruptcy cases filed in the country. So I think we'll be seeing a lot more subchapter 5 work, particularly here in Northern California. It's not going to cover, you know, the mega bankruptcies that are getting filed in Texas and Delaware and New York, but for the things that we see in the courts here, it'll probably be a majority of what we see.
Yep, good enough for us. All right, Carl's question probably goes to David. When can a corporation file dissolution after the bankruptcy or after an ABC? So, and what happens if the owner just reassigns all the assets back to the lender or pays things out? So basically, what's happening if people behind the scenes are doing some work, let's say, and you know, what are the rights there for everybody else?
I think frequently after a bankruptcy or an ABC, the parties just walk away from the entity. If you go to the Secretary of State's website, you'll see thousands of corporations that have been suspended where people have just abandoned them because it's just not worth it to file the final paperwork. So I think it's less common that you see people after a bankruptcy or ABC actually follow through and do the dissolution, because at that point, the assets are gone, the liabilities have been dealt with. I don't, Matt, do you, as part of your ABCs, do you actually wind down the entity, or do you leave that to the owners to decide?
No, it's typically part of the budget that the assignee handles. So you'll have, you sign the assignment on Monday, sale closes Monday at noon. The assignee then runs a sales process for whatever's left. They do a claims process, and a year or so later, they'll file final tax returns, and then they'll file the surrenders with the relevant state agencies, including the Secretary of State. It is a little different if you have a Delaware company. Delaware dissolutions, you file your certificate of dissolution at the beginning of the process, and it starts a 3-year time clock. So if you have any of your clients are Delaware entities, it's just one oddity between California and Delaware. ABCs in Delaware, obviously, or I'm sorry, not obviously, but ABCs in Delaware are actually a court supervised process. So that's an option available to any Delaware company, even if they're here in California. And it sometimes is helpful where you want some additional sort of supervision, or you want to give people additional comfort that there's a court overseeing this. And sometimes the buyers may want it because they want a court order approving the sale, but that's just a little aside.
Do you do
And
some of the bulk sales publications through your ABC to try and get the bulk sales protections, or no?
There's an exception in the bulk sale law for assignments. So we typically avoid that process. The assignees will do, they're obviously doing a commercially reasonable process to get as many, possible interested parties into the room. Even if there's a stalking horse, that's someone who has been identified and has made an offer. Even before the assignee has been hired, the assignee is going to go market test that offer by running even if it's a quick sales process, they're going to run one, because they have a fiduciary responsibility to creditors to make sure that they're getting the best that they can get.
And David, this next one is both for you and Matt again. When there's a winding up of the corporation LLC, how are creditors treated? So what if the business advises, they check that box that says that they've used all their assets to pay creditors, but there's still creditors out there. What can they do without, just trying to sue people in order to try and get that money? What protection is there out there for creditors? And Cheryl, you might know that answer too. I close down my business, I check that box, I file it with the Secretary of State. What's a creditor to do?
File suit. Fortunately, there's really not much else they can do. They can negotiate, if they know who the owners of the business were, and they can actually reach them and get a response to say, hey, what's going on? We don't want to sue you, but if you don't provide us some information, we will. But at the end of the day, they can try and sue the defunct entity, which can't afford to hire an attorney. And they're generally going to go after the shareholders if they know who they were or can find them. And then the shareholders have to show they're not personally liable and they didn't take any assets from the company, and you get nothing, Mr. or Mrs. Creditor.
Right. In the ABC process, that's where the claims noticing is important. The company will be asked to provide a list of people that they've done business with over a period of time, including anyone they owe money to currently. The assignee makes sure to send a notice to all of those people to present their claims. And then essentially there's a priority scheme that's established. So taxes, unfortunately, there's by statute, by law, government tax obligations have a priority. So there's going to get paid first. Employee wage claims are going to get paid. And then whatever, as you walk through the priority, as there's money left, that money is distributed on a per rata basis. So it's entirely possible you get down to the unsecured creditor pool, which could be most of your trade debt, your credit cards, litigation claims, and those people are not going to have much, if anything, to share. And absent showing some sort of malfeasance by shareholders or illegal distributions, there may not, as David indicated, there may not be very much to get.
Any other thoughts on that topic before we move on to the next one?
And unfortunately for the creditors, I mean, it's staying on top of your debtors. And, you know, at the end of the day, if you think that there's any possibility they could be going out of business, you better move quickly to file that suit and try and get a writ of attachment or some type of a prejudgment lien on the assets if you're an unsecured creditor, and hope that that 90-day window goes past before you all file bankruptcy to wipe that now temporarily secured creditor out.
Right. I think Cheryl talked a minute about preferences, and that's what David's referring to there, is that 90-day window. There is also a preference statute available in California to assignees, so they can also avoid preferences, which is a powerful tool.
So I received a question about wage claims. So let's say that you've got a wage claimant and the debtor goes in and files a bankruptcy. Is that wage claim going to be discharged? So again, we get this, it depends, right? So just like in ABCs, there is a priority amongst creditors. And so if you have a wage claim, let's say that Marta's company files bankruptcy tomorrow and she didn't pay you your last check, that claim gets a priority, right? And it should, right? We can, think that it should be paid. But let's say that instead there was an employee who worked for the company a year or two ago, and the company continued to do business, and the employee left or was fired, and they're not within that window, they're not a priority creditor. Their debt can be discharged if the debtor is getting a discharge. So remember, in Chapter 7, businesses don't get a discharge. But if an individual files a 7, or if an individual files a 13, debts are potentially dischargeable.
And one thing to be aware of, I actually had this come up. A young lady came to me to help me collect a debt based upon non-paid wages that the state of California got on her behalf. And unfortunately, at the time, the state was only going after entities. They weren't naming the owners as liable, and her time to amend her claim had run and go after the owners. And of course, she worked for a gym that COVID forced into bankruptcy, and her claim was unsecured because it was at that point a judgment, and she was discharged with nothing. And so it can be a disastrous result for employees.
And we highlighted in your materials just a couple of code sections that people are definitely going to want to look at. And one of those sections is 523, and that lists your exceptions to discharge. So Cheryl alluded to this earlier. A2, A4, and A6 have to be separately pled. So those are fraud, fiduciary, intentional acts, those sort of things. And there are other things that are just automatically not discharged. So your recent taxes are just never discharged. The spousal support I owe to Matt is not going to be discharged. This sort of stuff. It's funny because my husband's also named Matt, so it's a fun thing. But there's certain things that you do have to plead and certain things that you don't. So, and then these ones will get pled. I mean, honestly, most of these are going to get stipped out if there's separate litigation. We're gonna make an agreement that some debt's not dischargeable because we don't want the bankruptcy judge to find out about all this crap I pulled when I was a business owner. But if I don't want to do that, I can also say no, and we can have the long drawn out trial within the bankruptcy court, and the judge is going to hold like an actual trial on all of these materials, on willful conduct, on the fiduciary responsibilities. One thing to note, if you do represent creditors often, is that they're going to look at the justifiable reliance, and we have a series of cases out of our actual local court saying that the creditor did not justifiably rely on that information. And so then it's dischargeable. So
a question for you, Corrine, and I guess Cheryl, even though a 7 doesn't result in a discharge, because as a business owner, the business is gone, the corporation shall still exist, but the assets have been distributed to the known creditors. In reality, not getting a discharge doesn't really mean a whole lot, does it? It's not a going concern, and there's nothing for a creditor to get, and you abandon the entity, and okay, the debt sits there forever, but it's never going to change.
I mean, that's the basic thing. I mean, if there's litigation pending against the corporation, you file a Chapter 7, you're going to get the automatic stay for a while. And then if there's no assets, I mean, as a practical matter, most creditors just go away unless there's a guarantee that you can recover on or some other source of funds that you can go after, unrelated to the company that's now underwater, you know.
But most of the time, if I have an individual who's coming in and it's a mom and pop business, and you know, what we're going to end up doing is we're going to send them to somebody else to shut down the business, you know, file everything with the Secretary of State, and then they're going to file a personal BK, because there's no reason to have two cases and they're on all of the debt. And even if they think they're not on all the debt, they're on all the debt. I had a client come in where, I kid you not, it's a, you know, piece of paper, and they sign on the front page and you had to flip it over and look on the back, and it said, by signing on the front, you have guaranteed the entire thing. And the creditor filed that in their proof of claim. You know, they were upfront about it. They didn't try and hide it later, but you know, the poor individual didn't realize that they were on the hook for it. And so that is something that I advise everybody, is assume you're on the hook for the debt. And also just assume, you know, and a lot of these vendors and creditors, they're not going to put that on your credit report. So just because it's not on there doesn't mean that you don't owe that guarantee, because it's still going to be there.
Well, folks, we are 5 minutes before closing time. So if there are no more questions, then I have to plug our happy hour tomorrow. If I remember it correctly, it's at Jack's. I'm hosting, so please do join us. It is going to be spectacular. And also, yeah, come to the MCLE Spectacular when it's time to come to the MCLE Spectacular. I say goodbye to Sideways Wine with fondness in my heart. This was a Herculean project, and thank you for everybody who spoke today and at the other events. And thanks for David for speaking twice. This was so awesome. Carl, you have a question? Carl is that guy who doesn't let the class end. As for guarantees, one must always be vigilant of the sham guarantee doctrine that makes certain guarantees void and unenforceable. Yes. Sham guarantee doctrine. Thank you, Carl. It wasn't a question. It was a considered, well-put opinion, and we heart you. Thank you so much, everyone. You have a brilliant afternoon. Thank you to the CCCBA for hosting, and thanks to Ann Wolf for managing the multiple pinnings of the underpinnings of this here presentation today. Thank you. Thank you. Thank you. Mwah.
Thank you, Marta. Thank you, everyone. Have a great afternoon. We'll see you on Zoom or in person soon again.
See you in person tomorrow at
Tomorrow
Jack's.
night, Jax.
Tomorrow night, Jack's. Be there or be square.
Marta's a great host.
Yes.
All right. Bye.
Bye.